Hello, and welcome to today's presentation, Avoiding HIPAA Violations. My name is Rachel Rose, and I'm an attorney in Houston, Texas, where I've had my own law firm for over a decade. My practice primarily focuses on transactional compliance and litigation related to healthcare, cybersecurity, securities laws, the False Claims Act, and Dodd-Frank. I'm also fortunate to teach bioethics at Baylor College of Medicine, something that I have done for 9 years. Today, I'm presenting for Quimbee, and we're delighted to have you. No presentation is complete without a disclaimer, and the information presented here today is not meant to constitute legal advice. Consult an attorney for advice on a particular situation. Additionally, HIPAA, cybersecurity, and healthcare are all very dynamic areas of the law, and the information presented is current as of the date of the original recording. Given the dynamic nature of the topic, participants are encouraged to check the relevant government websites as well as case law for the most recent information. So let's begin. I always like to begin presentations with notable news. From there, I'll delve into cybersecurity terms and trends. Then I'll take you on a tour of HIPAA, the HITECH Act, and other relevant and related laws and rules. A new NIST publication was published related to telehealth, and that's something which is of interest to a lot of covered entities as well as their business associates and subcontractors. Additionally, I will give a hint of how to avoid HIPAA violations. And I'm going to do that by delving into instances where the Office for Civil Rights has penalized people, where there have been breaches, and also the illicit use of protected health information. From there, I'll delve back into the compliance side and I'll wrap up. So what are some noteworthy news items that relate to HIPAA? Well, first and foremost, ONC released information blocking by the numbers on its website. And information blocking is a component that relates back to the 21st Century Cures Act of 2016. In May of 2020, there were two final rules released. One was released by CMS, and then the other one was released by ONC. Now, the final rule that was released by ONC is the one that really delved into information blocking. And fundamentally, information blocking can be analogized in some ways to HIPAA's privacy law, whereby you have a requirement if you are a covered entity to provide a person with their designated health record set or medical records within a prescribed period of time. And the prescribed period of time under federal law is 30 days. However, it can be extended to 60 days. What is very notable is that states often have a shorter time period in order to get a patient their medical records. Not only a patient, but an authorized patient's representative, which could be a guardian, it could be a parent in certain circumstances if the person is a minor, or it could be someone with a durable medical power of attorney and someone who is released on the HIPAA authorization sheet. So those are all things to bear in mind. The intersection from my perspective between really the privacy rule, the security rule, and the component of information blocking is that A, it is related to getting the patients their information, as I just said. B, it says that the information needs to be provided to the patient in the manner that the patient requests. And because we've come a long way since 2005 in terms of technology, including apps on our smartphones, that is one way. The important notion for attorneys who often are business associates, subcontractors, and covered entities in particular to appreciate is that there are exceptions to information blocking, whereby a person may say, you know what, we will get you your medical records, but we're not going to send it to your TikTok account publicly. And those are all written exceptions in the information blocking final rule. So that's something to be very, very conscious of.